Good morning. Happy Tuesday. I hope everyone had a wonderful Memorial Day weekend. Remember, Josh, I was good enough not to say Happy Memorial Day, not even once the entire weekend. For you, buddy. For those of you who missed the live stream, and I don't blame you, it was 3.5 hours or thereabouts. The meat and bones of it was Michael Eline was completely freaking wrong once again. He had this whole question on whether or not you could file a group defamation action against the post office, and ultimately he boiled it down to, well, you probably won't win because you're probably a public figure, and so the actual malice standard would apply to you. Well, it's a lot easier than that. Normally, the United States, as a sovereign nation, has sovereign immunity, so you can't sue it for anything other than what it allows you to sue it for. State causes of action, states don't have power to make their particular state causes of action, their torts, their civil causes of action. They don't have the power to enforce those against the United States. The United States is a sovereign. You get a state court judgment. Even if you did get a state court judgment against the United States, it wouldn't mean anything. It's not worth the paper it's printed on. It's not enforceable. So the only thing that you can sue the United States for is for things that the United States allows you to sue it for. It has to allow you to sue. And each state has, the states that I am aware of, they will all have their own similar version where they allow you to sue them for specific things. Like we covered in New Mexico, they have the New Mexico Civil Rights Act, which allows you to sue New Mexico entities, state entities, sovereign entities, for violations of the New Mexico Civil Rights Act under certain circumstances. California has their Government Claims Act, which is in the Government Code section. And that allows you to sue various state entities like school boards or cities or counties, or even like the attorney general or whatever. You get to sue these various entities for torts, for money damages, for, you could say you had a duty, you violated, you breached the duty, you caused damage, and your violation was the proximate cause of the damage that I suffered. So the federal government has the Federal Tort Claims Act. That's what they have done to allow you to sue various portions of the United States government for violations of what would normally be a state law claim, right? Because if Congress doesn't have to have a Federal Torts Claim Act if they make a cause of action against the United States that's based on federal law. They don't need that. You don't need to have two. You just have the one. Congress says you can sue the federal government for this. You can sue the federal government for this. Congress says you want to sue for a tort, generally speaking, a state cause of action. Well, you could do that in certain circumstances as defined by the Federal Torts Claim Act. Well, there are exceptions to the Federal Torts Claim Act, Federal Tort Claims Act, that where you can't sue. There are certain torts that you can't sue the federal government for. And two of those torts are libel and slander, which means defamation in general you can't sue the federal government for. So can you sue the post office for defamation? No. Federal Tort Claims Act says no. No, you can't do it. So it's pretty easy right there. It's one and done. You don't have to really go into state law. But here's another stupid thing. If it is a group defamation claim, California doesn't have group defamation claims, but other states may. I think there's a couple of states that have group defamation claims, i.e. where you say like a group of people, like Corgi Breeders of America. Corgi Breeders of America is full of racists and homophobes or whatever. If you say that, the members of Corgi Breeders of America can come and sue you for group defamation in certain jurisdictions, in certain places. And so you'd have all the elements there, but his trying to tack on the public figure, the actual malice standard to it, doesn't make any sense, because public figure status requires you to be a public entity or a public figure, like either a famous person or a public official. It goes back to the New York Times versus Sullivan case. But you would have to essentially you would have to prove by clear and convincing evidence that the publisher, the person who said the defamatory things, the allegedly defamatory things, said those things either knowing that they were false about you, or that they were reckless, that they were they said it when they should have known it was false. So the reckless disregard to the truth or falsity. So like if they had done a modicum of research, they would have realized it was false. So, but they said it anyway, and so that's the actual malice standard. I know it has nothing to do with malice. It just means that they said it either knowing it was false or with reckless disregard as to whether it was true or false. But that's about you. Because you're the public figure, not the public group, the public figure. So trying to apply that as a additional element to a group defamation claim is nonsensical. And then he went off into DEI and stuff, and he doesn't understand that post offices may be under state jurisdiction. So federal enclaves, the way they work is if the federal government goes through the state legislature to get property, like, hey, state, we want this property, and the state legislature votes on it, and they come to an agreement, like, okay, federal government, our state legislature says you could have this, then it depends on a lot of things, but then the federal government may, and probably does, have jurisdiction over that area. But if the federal government, or say the post office says, you know what, this little community has grown, we want a post office in this community, so we're going to talk to Billy Bob, the landlord of this strip mall, and say we want to lease this space from him. And so they work out a deal with Billy Bob, not with the state legislature, but with Billy Bob to rent the space. Then the state retains jurisdiction over that space. So they don't need any agreement. They don't need any extraterritorial jurisdiction or whatever. They don't need to come up with any agreements. But in those instances where the post office has been designated a federal enclave for whatever reason, and where the state does not have concurrent jurisdiction to enforce state law, the federal government can still enter into an agreement with the post office can enter into an agreement. There is a provision in 39 CFR, the post office portion of the Code of Federal Regulations, where the post office in its regulations says that the postmaster, etc., can enter into agreements with local law enforcement to enforce laws to make sure that the rules for conduct on postal property are followed. So it's all stupid. It's all stupid. The whole thing was stupid. Anyway, Eline privatized it, apparently. He's going to have to go in and make some edits before he republishes it, because he was entirely stupid the entire time. Par for the course. And I'm just wondering, like, if I just go through like every night and I do a video, I'm not saying I have time to do that, but if I just did one of his videos a night, just went through it and picked it apart, like how stupid he is, I wonder if I can get him to privatize his whole catalog. Wouldn't that be interesting? Make him spend millions of hours editing. Where the hell does he have time to edit anyway? I mean, you know, maybe he has a lot of time. Maybe he has a lot of underlings doing his dirty work for him, so he has plenty of time to make videos and edit them. Probably. But this is why I sit in my car right before I walk into the door and spout shit off the top of my head. It's because I don't have a lot of time to make videos, and I wouldn't care to make them. I would spend my free time in other ways, even if I had the free time, which I do, but I spend it in other ways. Anyway, thanks for watching. Have a great day.